Hi, hello everyone, and welcome to today's event. The event will be recorded. My name is Ermioni Xanthopoulou. I'm a senior lecturer in law here at Brunel University London, and I'm pleased to host this fantastic line of speakers, all experts in today's topic. I'm also pleased to see friends and colleagues joining our audience. So the aim of today's panel is to understand what externalization in asylum law is, who its actors are, how it is performed, or what the impact of externalization is. This is a fascinating topic that has been studied considerably by a number of colleagues, but current political developments in the UK and in the EU keep offering fresh opportunities to approach questions on externalization again and in a timely manner. Before we begin our discussion, I would like to invite everyone from the audience to submit their questions in the Q&A box so that we consider your perspectives and your questions. So we will start with our first panelist, Professor David Cantor, who needs no introduction. David is the founding director of the Refugee Law Initiative and its internal displacement research program at the School of Advanced Study at University of London. His presentation is entitled Externalization in the Asylum Context. What is it and why does it matter legally? David, the floor is yours for the next 15 minutes or so.
Excellent. Many thanks indeed, Ermioni, for the invitation. And I'm very pleased to stand in for Nick Tan, who was the original speaker and on whose behalf I'll be presenting some comments. Well, I think a good starting point for thinking about these themes is the fact that both scholars and practitioners have become increasingly concerned over the last number of years, or perhaps even recent decades, with this phenomenon or measures that they label externalization. Now, some of the most recent measures are ones that seem to have to do with the outsourcing of asylum, as per the title of this event. And really what these measures involve is preventing asylum seekers from gaining access to asylum in the country in which they are seeking to stay. Clear examples of this are the Australia-Pacific solution. Possible other ones include the US Stay in Mexico plan, things like the EU-Turkey arrangement, some of the EU's cooperation agreements with, for example, North African countries, which I'm sure other speakers will be dwelling on in much more detail. More topically, though, Denmark over the last few years was considering a scheme of third country processing for asylum claimants arriving in its territory. I understand from my colleague, Dr. Nick Tan, that Denmark has actually moved back from this position and is no longer exploring this so actively, which I think must be a good move. But that should be weighed against the fact that, as most of you are probably aware, the United Kingdom recently concluded a deal with Rwanda for third country processing, and the illegal migration bill, which is currently whizzing its way through Parliament in the UK, provides some of the legal basis for asylum seekers to be denied admissibility to procedures here and instead sent for third country processing, and indeed ultimately, if recognised as refugees, for international protection in Rwanda. But this kind of outsourcing isn't the only way in which externalisation works. There are other forms of externalisation that are also equally relevant to asylum seekers. And here we're really talking about the interception of migrants, amongst them people travelling to seek asylum, before they arrive in their destination country. Now, some clear examples of this include things like the well-known EU measures in the Mediterranean, but also things like the imposition of carrier sanctions and, of course, visa regimes. Now, these sorts of measures are by no means recent. In fact, as we detail in a paper that we published last year on the issue, a background paper for the RLI Declaration, these measures have a long history, with visas having been imposed at least as early as 1924 in the United States, some 100 years ago, and during the 1800s for carrier sanctions. So these are part of a much wider process of externalisation in terms of the impact on movement of persons. But how can we conceptualise this phenomenon of externalisation? And especially, how can we do this for the purpose of trying to work out what it means legally? And this really is where the Refugee Law Initiative Declaration on Externalisation and Asylum tries to make a contribution. This declaration reflects the distinctive contribution that we felt that the Refugee Law Initiative would be well placed to make in the field of refugee law on such topical but complex legal questions. At the RLI, we host extensive networks of around 300 research affiliates spread out across the world, and the declaration draws on the refugee law expertise of these global networks to develop targeted legal guidance on protection of refugees and other displaced persons. The audience for these declarations is not only scholars like ourselves, but also national and regional courts, international NGOs, international organisations, and of course, ultimately, governments. So I think the RLI Declaration on Externalisation and Asylum makes a number of potentially useful contributions to thinking about externalisation in this particular field. One of the contributions that it makes to understanding these complex processes is that it proposes an analytical declaration of externalisation. And the reason why it does this is because externalisation is not a legal term of art that's defined in law. And scholars and others, UNHCR, for example, have put forward definitions or understandings of the term that can sometimes differ quite widely. Nonetheless, we define the term externalisation as the process of shifting functions normally undertaken by a state within its own territory, so they take place in part or in whole outside its territory. This really highlights two key points. Firstly, externalisation is a process, and it's a process that's confined not merely to the issue of asylum, but rather connects with broader policy currents in today's world. One can see externalisation of state functions in the defence sphere, in education, and so on. Secondly, the process is not defined by reference only to migration or only to asylum, as some of the other definitions are. Rather, this definition allows us to connect analytically and legally similar issues across measures in the separate but connected migration and asylum fields. In short, externalisation functions as an umbrella concept in those regards. Crucially, in relation to this extraterritorial core of externalisation processes, the RLI Declaration explains where and how relevant regimes of international law, including human rights law, refugee law, IHL, and the law of the sea, both within the UN platforms and also in regional organisations, how those regimes of international law continue to function to regulate these kinds of externalised measures when they concern the extraterritorialisation or externalisation of core state functions of, on the one hand, operating border controls, and on the other, administering national asylum systems. A second definitional contribution that the Declaration emphasises is that in practice, externalisation often involves attempts to shift responsibility, or in your terms, outsource responsibility for the measures to other kinds of entities. It could be other states, it could be international organisations, it could even be private actors. We don't see this as a necessary element of externalisation because some externalisation processes are carried out unilaterally by a state. Nonetheless, although these kinds of externalised functions can be implemented unilaterally by a single state, they are quite often implemented jointly with other states and/or entities. The Declaration, therefore, clarifies how the international legal rules, the secondary regime of responsibility, works in such contexts of cooperation and potential outsourcing. Well, building on this analytical and legal foundation, I think there are a couple of other areas where the declaration is useful in setting out how the legal parameters established in international law serve to regulate these processes of externalisation. I think it's worth emphasising that the declaration takes the position that not all forms of externalisation are necessarily unlawful. This isn't to say that they're desirable or morally appropriate, but that international law doesn't necessarily characterise all forms of externalisation, even in the asylum and migration fields, as unlawful. But it's very clear that not all forms of externalisation are lawful either. And so the declaration serves as, if you like, a touchstone to work out where and how, or against which standards, the legality of these sorts of measures should be assessed. As I mentioned earlier, it does so in relation to two main themes or functions. The first of these is externalised border controls, and the second of these is the externalised national asylum systems that I think are really the focus of today. On the first of these topics around externalised border controls, I think that there are really two key rules that one can derive from the RLI declaration. And the first is a general principle, if you like, that measures that would be carried out for purposes of border control, if they were unlawful within the territory of a state, will equally be unlawful if they are carried out by that state in a territory or location outside its own territory, in particular where it has effective control over the location or the person in relation to whom those functions are being exercised. Secondarily, though, the declaration makes the point that international law seems to have developed to the point where there's a fairly good case that even where the state isn't exercising some kind of physical or effective control over the person or location, nonetheless, where the externalisation measures form part of a chain of conduct that directly exposes an individual to a breach of their human rights, then in those contexts, equally, the measures may be unlawful. So although the declaration provides a great deal more detail around those particular principles, I think that those are the two core ones. Moving on then to think about externalised asylum systems, when we think about third country processing, it's not only in relation to sending asylum claimants who may be intercepted before they arrive in a state's territory or once they have arrived there. It's not only sending them to another territory for processing, but often that will include the provision of international protection in that third country as well. But when we talk about third country processing, we're using this here just as a shorthand, potentially for both of those things. Now, the declaration illustrates a number of important points in relation to this. And I would suggest that, if you're keen to see exactly how the legal rules apply in the opinion of the RLI, then you take a close look at the RLI declaration. Nonetheless, some of the main areas that we touch upon are to suggest that the form and content of international agreements around third country processing are subject to certain legal and policy parameters. For example, it's clear that the form of such arrangements should, in principle, be one that is adequate for protecting the rights of persons who are going to be transferred under its auspices. Equally, there is a need to establish supervisory mechanisms in relation to that. So the first point is about when states seek to enter into agreements with other states or entities, what kind of provisions and what form should those agreements take? The declaration is also very clear that there's a need for pre-transfer procedures to be in place in order to assess the legality of transfers carried out under these arrangements. And we suggest that some of the elements are legally required and others are recommended for policy reasons. And of course, that the procedures there and in any third country need to abide by minimum procedural standards to ensure that they are fair and efficient. I think one of the more interesting areas in relation to the third country processing is that we take the stance that these kinds of third country processing arrangements, a key principle is that they cannot be used to outsource or escape obligations. So transfers under third country processing arrangements aren't just removals. They involve a transfer of responsibility. And if you look at a number of areas of international law where states transfer responsibility, then that produces certain kinds of obligations in relation to the transferring state, but also in relation to the kind of obligations that the receiving state must assume as well. We also take the point very closely related that the outsourcing can't be done in a way that's inconsistent with the state's international legal obligations. And those in the asylum context would include the idea of burden sharing and good faith in relation to asylum claims, mass influx, and so on. And I think it's really here where the UK scheme falls down, because the UK scheme effectively appears to attempt to decline to process claims for very spurious reasons without really providing any reasonable alternative. So it inverts the principle of territorial asylum rather than observing that fundamental obligation, which is the mainstay of refugee law. Lastly, I'd just like to say that the declaration emphasizes, in relation to the theme of accountability, the fact that pathways for accountability in domestic law tend to be quite limited in many contexts, and that there is a need to develop more robust monitoring mechanisms and also domestic legal pathways to challenge these sorts of arrangements. Thank you very much for giving me the platform to present this, and I'm very happy to take questions. I think you're muted.
Yes, I was muted. Thank you, David. Thank you so much for your presentation. That was such an informative presentation, shedding light on the concept of externalization and the practices of states, as well as their legal obligations. And also thank you for pointing out to the RLI declaration on externalization that is a key text. Necessary starting point for all of us interested in asylum. So I have added a link in the chat box for everyone to have a look. Off to our next speaker, Dr. Piero Sullo. Piero is a reader in law at Brunel University London, and his presentation is entitled Externalisation of Borders, State Actors and the EU, Human Rights Under Threat. So Piero, the floor is yours for another 15 minutes.
Ermioni, many thanks for this. I'm very pleased to participate in this webinar today, and I would like to thank not only Ermioni, but the organizer of this webinar, and in particular the colleagues that since a long time are active in running the International Law Group research group, and also the Human Rights Law Research Group at Brunel, because they are making a fantastic job. Many thanks. Well, my presentation will be focused mostly on some general introductory remarks on this phenomenon, which has already been very comprehensively in-depth addressed by Professor Cantor, and then I will take the liberty to discuss shortly some actual instances of externalization, and to present, if I do have time, one of the cases which points to the clear lack of accountability for human rights violation that also Professor Cantor has highlighted, which is represented by the EU agency Frontex. In general, externalization is receiving, both in the academic world, but also in terms of policy actors, a great attention at the moment. It provides definitely several challenges also for human rights lawyers, because to some extent, although it's neither a phenomenon which is allowed under international law nor prohibited, somehow it exploits, or at least actors involved in this field, in particular states and international organizations, exploit blind areas that exist, gray areas in international law where some phenomena are not explicitly regulated. And I think that the declaration of the Refugee Law Initiatives, which I've read with great pleasure and is a permanent source of inspiration for me, has done an excellent job in highlighting the fact that there is a legal framework provided by international law that can be applied while states work on the externalization of asylum procedures and borders control. I would like also to stress the fact that very often nowadays, as we know, asylum-related issues and current challenges are unfortunately discussed under the paradigm of the crisis which is normally attributed to increasing or continuous migration and asylum flows. I do not agree with this view. On the contrary, I think that migration and in particular asylum flows are a matter of human rights, and to frame them within the paradigm of the crisis, of the securitization, and also inventing challenges for security and safety in the global north is definitely not the right approach. I think that it's particularly interesting to highlight that it's a crisis of politics mostly, and politics tries to find solution in the law, which definitely in asylum-related matters does not play a neutral role at all. And it's particularly interesting to see what the results of the current legal framework, I refer to the framework externalizing asylum processes, creates. It creates, I think, potential lawless spaces, spaces where it's particularly difficult to implement the existing asylum acquis and the entire framework provided by international human rights law. And there is a wonderful article of Daria Davitti that somehow highlights that the current crisis is also the byproduct of politics and of the current legal regime. In general, migration has had a very, very important role in the development of international law, which is very much intertwined with what many centuries ago was defined as ius migrandi, the right to migrate, which was one of the key pillars of was considered one of the key pillars of public international law in the past. We see that now that available instruments allow this ius migrandi, the right to move and the right to ask asylum, also towards the global north, which is composed to a large extent also of former colonial powers. Externalization is used somehow to challenge access to asylum, very often also infringing upon human rights. As Professor Cantor has already highlighted, externalization has several forms, and it's not a new phenomenon. What is new nowadays is the fact that it is very often used to limit access to asylum, at least asylum in the global north. And it's worth, I think, to mention that this process does not imply, the externalization process, any encouragement in terms of access to asylum, rather the opposite. Although third countries are involved in this externalization process, a key feature that needs to be taken into account when we discuss externalization of the common European asylum system is that it does not apply outside of the EU territory, which means that basically, at least the European Union does not provide safe and legal regulated entry opportunities to asylum seekers within the EU territory. What does this mean? This means that it's the legal framework in place in Europe, I think, that encourages smugglers and forces asylum seekers and protection seekers to enter illegal our territory, which is very often used as an excuse to reinforce our borders and to externalize them in a way that is aimed at keeping far away migration flows. In the last years, the Court of Justice of the European Union, and in particular the European Union as a whole, has had the opportunity somehow to redress, at least partially, this issue of access, regulated or unregulated access to its territory. It has had this opportunity when dealing with a famous case surrounding a family of Syrian asylum seekers, which goes under the name X and X against Belgium. I would like to mention this case as a missed opportunity of the EU in terms of legally providing a regulated access to its territory. In a nutshell, the case regarded a family of asylum seekers who managed to flee the siege of the city of Aleppo and to apply for asylum at the Belgian embassy in Beirut. Here they made the argument that was later upheld also by Mengozzi at the Court of Justice of the European Union, according to which asking for would be legitimate to ask under EU law for a visa, which a temporary visa, which would allow access then to the territory and the possibility for this family to apply as for asylum within the territory of the European Union. This because implementing the visa code of the EU implies implementing EU law, and consequently the Charter of Fundamental Rights, which guarantees also access, right to asylum, should be implemented with all its guarantees. This was unfortunately not the approach of the Court of Justice, which has considered such a reasoning which would jeopardize the key pillars of the common European asylum system, and in particular, the fact that under the Dublin III regulation, asylum seekers cannot choose their country of destination. So within this framework, different initiatives have been adopted to outsource and externalize asylum procedures. Very often they are characterized by bilateral agreements, either on the side of the European Union or on the side of member states with third countries. Among these agreements, it's very famous, the EU-Turkey statement of 2016, which very strangely had the form of a statement of a press release, which was included on the web page on the EU Council. This has triggered a lot of doubts regarding, of course, its binding or not binding nature, and has also triggered, of course, several issues in terms of accountability. Similar forms have been adopted by other countries. Among others, I would like to refer to the Memorandum of Understanding between Italy and Niger, which whose text has been not made available by Italian authorities for a very long amount of time, and also the very, very controversial Memorandum of Understanding between Italy and Libya of 2016 that has been renewed for 3 more years in 2020. This Memorandum of Understanding, again, which does not assume, does not have the form of a legally binding international treaty, to avoid, of course, the scrutiny of the Italian Parliament in the phase of ratification. And it also avoids in this way judicial scrutiny, has been very much in the spotlight. We are all aware of the fact that currently Libya, unfortunately, provides a sort of free market for slavery. It has been the situation in Libya under investigation of the prosecutor of the International Criminal Courts, and there is no doubt that international crimes are committed. This agreement, in a nutshell, provides aid to the Libyan Coastal Guard and training, which is aimed at enacting operations which are known as pullback operation. Libya prevents migration flows on behalf of Italy, and sometimes, of course, somehow this represents a form of anticipated preventive border control. This agreement has also triggered concerns on the side of the Council of Europe, which has recently written to Italy asking for not to renew it. However, the Foreign Ministry of Italy has highlighted that it is—
1 minute, Piero, sorry.
Thank you, Ermioni. Extremely effective in deterring illegal migration flows which are not illegal, if we consider that until these people reach the shore of the European Union and they apply for asylum, they become automatically legal. So we are in a context where definitely outsourcing is creating very serious human rights concerns. I don't have time, and I'm guilty for it, to address Frontex. I just would like to anticipate that this agency, which is in charge with the control of external board of the European Union, has been increasingly under human rights scrutiny from civil society, the European Parliament, the OLAF, and the way it runs its joint operations makes it very difficult to understand who is responsible for human rights violation. But this human rights violations are extremely well documented. So to find the right remedy for this approach to asylum is definitely a very urgent matter. Many thanks.
Thank you so much, Piero. Thank you for your critical insight on externalization framework that is so much needed, and on pointing to human rights issues and, of course, accountability issues that are created by the informal dimension of externalization and the lack of transparency in the operation of Frontex and other agencies. Luisa is also going to touch upon agencies later on, so we'll have the touch to expand on this aspect of discussion. Our next speaker is Ms. Vasiliki Apatzidou, who is a PhD candidate at Queen Mary University of London and a legal advisor and field practitioner with EASO. Her presentation is entitled "The Shifting Borders in the EU, Externalization versus Internalization." Vasiliki, over to you.
Hello, good morning to everyone. Thank you very much for the introduction, and also thank you very much for inviting me to this event. It's indeed a very interesting topic to discuss. So today, indeed, my presentation will focus mostly on the shifting borders theory that is taking place in the European Union. And I will not only refer to cases of externalization, because also the previous speakers referred to it, but I want also to focus on some issues of internalization that are taking place in the European Union, and which is also the main topic of my PhD thesis. So in order to explain the externalization and internalization policies of the European Union, I actually engage mostly with the work of Eilert Sahar and the theory of shifted borders. So what actually this theory mentions is that the black lines we see in the maps do not always correspond to the borders of the state. It is like the border is moving, sometimes far away from the state's territory, and in this case we have the cases of externalizations or debordering practices, and in other cases the border is actually moving into the state's interior, which is the cases of rebordering or the cases of internalization. So we see that in reality, the European Union and the EU member states use some legal techniques or some legal maneuvers and fictions and tools in order to restrict mobility by detaching the border and its migration control functions from a fixed territorial marker, creating a new framework that is the shifting borders. So this means that partially the border is actually losing the territorial significance and becomes subject to the desires and the policy aims of the state. First of all, I want to refer to the cases of externalization, although I will not analyze them because the previous two speakers have already referred to the most important examples, and they have also mentioned the definition. So externalization is the case of stretching the border outwards, which means actually it's like the countries are saying that it's better to before migrants come and ask to be let in, it is better to prevent them even from leaving their country or even from reaching the territory of the European Union. There are many examples that already the two previous speakers have referred. And what I'm actually doing is to divide these externalization measures between these that are focused on development and those that are focused on security. So in the case of the development approach, there is a range of bilateral and multilateral initiatives that have focused on strengthening protection capacity in regions of origin in order to reduce the so-called push factors and enhance the protection, and in other cases to enhance border control in these cases. There are some examples like capacity building missions in Niger or the operations in Libya, other EU funds that are being given in third states, such as the EU Trust Fund for Africa, and other soft law instruments and soft law cooperation between the European Union and third states, like the Joint Way Forward with Afghanistan and other agreements with third states in order to enhance their capacity and in this way to prevent people even from leaving the countries and leaving the EU territory. On the other hand, EU is also adopting many security-focused externalization measures, and Professor Cantor referred to them, like the imposition of visa regimes, career sanctions, interceptions on the high seas, and of course increased surveillance that we witness in the borders of the European Union. So these are all methods of exclusion and deterrence in order to reduce irregular migration in the European Union. So we either see that there are measures that are focused either on development or security, but the main aim of externalization is actually to prevent asylum seekers from reaching the EU territory or prevent them from leaving the country. Another case is the case of readmission agreements that Professor Sullo actually referred to before, which is actually the case when either the European Union or the member states decide to agree with a third state for the readmission of the illegally staying third country nationals, the return of these people. And this is happening, of course, in exchange of something. And we have already referred to the EU-Turkey deal between the European Union and Turkey, where actually Turkey has agreed to take back the illegally moving asylum seekers that are going to the Greek border islands. And in exchange of this, Turkey received some financial contribution, and it also asked for a visa liberalization scheme in order to ensure that Turkish nationals can travel without a visa in the Schengen zone. The Italy-Libya Memorandum of Understanding, of course, is another agreement which has the same logic. And also there was the Spanish-Morocco cooperation agreement. Again, Spain has agreed with Morocco to give some operational and financial support to Morocco, and in exchange of this, Morocco to take back the illegally staying third country nationals. I also want to refer to a case that is taking place outside the European Union. It's the case of UK and Rwanda. We have also referred to it, but it's the most recent readmission agreement. And according to this agreement, those who have their asylum claim deemed as inadmissible under the UK inadmissibility rules and have made a dangerous and illegal journey to the UK may be relocated to Rwanda for the processing under their asylum system. So with the case of readmission agreements, already Professor Sullo has referred to the informalization that actually these readmission agreements are taking place through informal means like press statements, memorandum of understanding, cooperation agreements. So it's really difficult to bring an action against these agreements in the court. And also the human rights situation in the third countries that the EU is cooperating with, like the human rights situation in Libya, in Morocco, or in Turkey is contested, especially the human rights situation of asylum seekers. So these are the cases of externalization. These are just some examples, and also the previous speakers referred to them. But although external border control and externalization of asylum remains a priority for the European Union, and it's something that we witness in the EU, we see that the policies and legislation that were adopted during the so-called refugee crisis indicated another crucial component of the EU policy, and this was the confinement of asylum management at the EU's borders and the confinement of asylum seekers at the borders. This was the main policy aim of the European Union and response to the so-called refugee crisis. So this development, I believe it can be captured by the inward border shifting that I referred in the beginning, which means a case of internalization. And a very indicative example is the case of border procedures, which is actually the topic of my thesis. So I want now to explain why I believe that the case of border procedures actually is a case of internalization, meaning shifting the border inwards. So border procedures are actually taking place in the territory of the member states. There is no contestation, even if they are taking place in the border areas. These areas are under the jurisdiction of the state. An indicative example is the case of Greece, where border procedures are implemented in the Greek islands, Lesbos, Samos, Kosios, and Leros since 2015. So for the last 7 years, border procedures are actually implemented in the Greek islands. And of course, there is no contestation that the Greek islands are under the jurisdiction of the state. And of course, the persons that are in the Greek islands are bound both by national law and EU law, of course. So although territoriality matters, an exception can be noticed at the borders of the state, where a less protective legal framework may actually apply. So what we see is that through border procedures, it is allowed to implement a less protective legal framework. So it is like the states remove some parts of their territory, usually the border areas, from domestic and other European legal guarantees that are applicable to asylum seekers that have their asylum claim examined in the state, in the territory of the state, in the mainland, usually in the context of a regular asylum procedure. So the denial of law towards asylum seekers is often witnessed in the border areas because many states implement border procedures. So through shifting the border inward, states manage to prevent asylum seekers, not this time from accessing the territory, as we mentioned in the case of externalization, but from accessing the full set of laws and legal guarantees that are envisaged in the European legislation. And how this can actually happen? This can happen through the non-entry fiction that is applicable in border procedures, which means that the asylum seekers that have their asylum claim examined in a border procedure are treated as not entered into the territory. This is also mentioned in the Asylum Procedure Directive and now in the current proposal on an asylum procedure regulation, where it is mentioned that the asylum border procedure should be conducted without granting entry to the asylum applicant. However, this is a fiction because we cannot prevent entry from someone that is already in the territory of the member state. So it's a legal fiction that allows to treat a third country nationals at the borders as not entered into the territory, and in this way to justify a less protective legal framework, an asylum procedure that has legal guarantees that are actually undermined. So the asylum border procedures are now implemented in many member states, but through the EU Pact on Migration and Asylum that was proposed in 2020, the EU Commission actually proposes the establishment of a pre-entry phase in the European borders, which will be consisted of a screening procedure, of an asylum border procedure, and of a return border procedure, and where the non-entry fiction will be applicable. So we see how this pre-entry phase will be used as a migration management tool to actually prevent people from accessing the full set of laws and rights. So we notice an extension of border procedures and the mainstreaming, which in some cases even become obligatory. Of course, the current framework is currently under negotiations, but we see that specifically there is some member states and the Commission actually insist on the wider use of border procedure. So of course, the impact of this shifting border practices on human rights is very important. On the one hand, we have the cases of externalization, where the people are prevented from accessing the territory of the European Union, and in this way from accessing asylum. And on the other hand, in the cases of border procedures, we have the preventions of asylum seekers from accessing the law. And of course, this can have also an impact on the right to asylum, the prohibition of refoulement. Of course, the procedural guarantees on border procedures are limited, such as accessing to legal assistance or interpretation, the right to an effective remedy, because in border procedures, there's no automatic suspessive effect of the appeal. And finally, we notice that border procedures are usually taking place in detention or de facto detention. So there is also an impact on the right to freedom of movement and the right to liberty. Of course, border procedures should be, are implemented in detention, because the aim of border procedures, as I mentioned, is to prevent the entry of asylum seekers. So they need to be contained in border areas. And now, in order to conclude, of course, this shifting border practice is taking place in the European Union. We witness it very often, but we need to look for a response. Professor Cantor also referred before to the extraterritorial reach of human rights in the case of externalization. Sahar, in her book on shifting borders theory, also proposed that the human rights framework should follow the border. And also Moreno Lax has referred to the functional model for the cases of contactless control, which means actually that we should be based on the normative foundation of sovereign authority, wherever it may be exercised. So the functional model is based on the exercise of public powers, even if control is exercised via remote management techniques or through a proxy third actor. However, the situation is more complicated in the case of border procedures, because, as I mentioned, they are taking place in the territory of the member state. So in this case, there is no contestation that the human rights framework should be applicable. But what we witness is that the border procedures actually institutionalize and normalize an exceptional regime at the borders, where a less protective framework applies for asylum seekers, because asylum seekers are treated as not entered. And despite the fact that many civil society organizations, human rights actors have published reports that prove that the border procedures have a serious impact on the rights of asylum seekers at the borders, we see that both the Commission and the member states in the current negotiations focus on the wider use of border procedures. And also, we see that in some cases they become even obligatory. So we see that actually border procedures persist and they are about to stay. This is what I see. And so what I'm trying to research also on my thesis is what is and how actually human rights can be protected in the context of border procedures, and if finally border procedures can fit in the current human rights framework. Otherwise, another approach. We should look for another approach in order to mitigate the rights restricting effects of border procedures. So I won't end with just this question that we can also discuss later in the discussion, if there is finally an end to this shifting border practice, and how can we respond to this. Thank you very much for your attention, and I'm also looking forward to the discussion that's following.
Thank you, Vasiliki. Thank you so much for your presentation, for offering also theoretical account underpinning for this discussion, that of shifting borders, and also pointing to how the European territory might be transforming and how do we respond to this in terms of accountability and human rights protection. Luisa has also shared an article that she has co-written on this topic. It is in the chat for everyone to see. I will also add in the chat your Vasiliki's recent blog post. I think it is about the normalization of this trend of denying rights and safeguards at the border, in light especially of the new legislation, EU legislation reforming the CAS. So that is also something interesting for us to read and consider. So we are moving now to our next speaker, Dr. Luisa Marin. I will remove Vasiliki from the spotlight and add Luisa spotlight. So Luisa is a Mary Skłodowska-Curie Research Fellow at the European University Institute and a Senior Assistant Professor at the University of Insubria. Welcome, Luisa. Her presentation is on the role of EU agencies and the rule of law crisis unfolding at the external borders of the EU, a really topical and important topic. So we are looking forward to your presentation.
Yes, I'm trying to share my screen and in particular the presentation. I don't know what you see.
We can see now your whole screen.
And
yes,
now
we can see your PowerPoint presentation now.
Okay, good. Okay, does it work?
The moment, sorry, it does work. Yes, we can see the whole thing. Yes.
Okay, are you at the first slide now as I see it, or?
The first slide, yes, we can see your very first slide. Yeah, the first.
Okay, perfect. Okay, no, thanks Ermioni for the invitation and for the organization, and yeah, it's very much a pleasure for me to be here and to talk about my recent research. I'm working on these topics indeed for my Marie Curie project, and I think that also, yeah, the past years have been really intense, and you know, they really make it urgent to work on these issues, but also to find solutions to improve the situation. I think we as lawyers, we can't really just stand and observe what's going on, but I think for me at least it's really time to come with solutions to overcome this situation, which is problematic in many aspects. And I think that also I'm very pleased to be after yeah, all of you, because I think that you have kind of already paved the way for yeah, a part of my let's say a part of my speech. So I think that it's really like yeah, the right moment for me to be here precisely after Vasiliki, because actually I'm thinking at framing the operation of migration agencies. I'm mainly working on Frontex, I have to say, I have to confess. I think that Frontex is really the most problematic agency. It's not only my opinion, I think that the fact witnessed it. And I think it is also time to frame the operation of this agency as a rule of law challenge. So I think that, yeah, this is a broader framework than fundamental rights. And I think that this might be indeed a framework which is successful for finding solutions to the problem that the operation of Frontex is showing. So actually, indeed, this is a bit the framing of my work. And I think that, yeah, what you've stated before is precisely that we see many externalization policies that conceal, in terms of policies, at the end of the day, containment and preemption strategies, deterrence of migration fluxes, and more. And I think that the common trend of all these different trends that have been highlighted by David, by Pietro, but also precisely by Vasiliki, precisely on this internalization of the externalization practices, is that there is a form of informalization. And also, at the end of the day, this is a form of escape from law. So we are seeing, it has been spoken about delegalization. I mean, several scholars frame it in different ways, but what we are seeing is really an escape from law. And in this respect, my perspective, my very, let's say, original perspective is a constitutional law perspective. So you can imagine how, we are kind of, in conflict with the world that we have seen so far, and the year 2000 have been, but I mean, since decades there is a process that has been framed as low intensity constitutionalization of the European legal order. So we have been growing up with the literature talking about the constitutionalization of the European legal order. The Charter of Fundamental Rights is also epitomizing this process. And we have been talking about for decades about integration through law. So you can imagine that now someone who is studying migration, border, and asylum is kind of in conflict with this systemic idea of European Union legal order. And I think this is indeed, these policies, okay, are different policies, but nevertheless, we have to really go to the core of the question, is there a single idea of legality in the European legal order? Because I think that the answer has to be yes, but in reality, we are not seeing this, okay? So then the answer is a normative answer. And I think that there I see that, as lawyers, we have to say something about it, because I can really understand that different policies work in different ways. Okay, but the very idea of legality must be the same. Otherwise, we can't talk anymore about a single legal order. Okay, so I'm focusing on rule of law, agencies, and remedies. So I also want to put forward some ideas for remedies. The fact that I come also after you is also that I'm going to be a bit more quicker on the problems, so to say, because I think that we are really witnessing this accountability and this rule of law problems. And I think it's also time to think about the remedies. And one of the things I've been working on lately is the management board of Frontex, which is very important and which is the first internal oversight instrument of Frontex. Secondly, I've been working on conditionality and financial accountability. And the last strand of research is about rethinking effective remedies. But this is something I can only touch upon, and I can't say much about it because otherwise I won't be speaking for 15 minutes, but more. So in short, I say that there is a rule of law crisis at the external border of the European Union, and it's not me who said that, but it is indeed strongly proved. But what I say is that this rule of law crisis concerns as well the European administrative level, and it means agencies and it means Frontex. So very good evidence of systemic border violence. It has been framed in the scholarship as refugee protection backsliding by Zurdi, as border control crisis and violation of non-refoulement practices by Goldner, Lang, and Nagy. Earlier on, also, Gatta has has made a connection between rule of law crisis and migration crisis. What's the core of this different nuance of rule of law crisis? We are not thinking here at the constitutional capture of the Visegrad state, but we are thinking at a strong implementation gap between the written law and the practice. We are thinking at systematic violations of fundamental rights, okay, systematic violation of fundamental rights. And also part of this picture is framing externalization as an institutionalized escape from law, which means duties and which means obligations, okay? So in this respect, the literature is abundant. I refer to Zurdi, but also to Violeta Moreno and so. So basically what I'm saying is that what we have witnessed in the past with the mandate of Leggeri, who resigned last year, is also an epitomize of a rule of law crisis within Frontex. This can be called as an organizational capture based on a constitutional capture by Müller. And in the sense that he has been, let's say, setting up a way of working of the agency, which is really in contrast with the law. How? Systematic disregard of fundamental rights, obligations inside, of the agency, but also inside the agency at the organizational level. Why? Circumventing the role of the fundamental rights officer, and also hindering the hiring of fundamental rights monitors. And there is also a systematic non-integration of fundamental rights provisions in the agency, in the functioning of the agencies. This has been very well documented in the reality. And what is even more dramatic is the Olaf report that has been eventually leaked and not published first by the institution. So the Olaf report has been leaked. Just to say that transparency is also a problem. So the Olaf report has managed to ascertain what the European Parliament did not manage to ascertain, and also what the internal investigating body of the management board did not ascertain. Okay, so the Olaf report proves more about what Frontex has done with pushback in Greece, and with the practices also concerning the role of the fundamental rights officer, and also more broadly the conduct of the executive director toward the commission, etc. So violation of rules concerning the functioning of the agency, and that means that there has been a systemic violation of the rules of the agency, which means therefore also a violation of the rule of law in the sense of rule by law, in the sense of legality, but also in the sense of a thicker meaning of rule of law, which is the meaning that has been emerging in the 20th century, which is integrating also fundamental rights and scrutiny in the meaning of rule of law. Framing of context, but I have to be very quick because I'm getting close to the end of my time. So I think that, other aspects of Frontex and the operation of these agencies and agentification in this context are problematic. For example, digitalization, externalization, there are several elements of the external border management that are problematic. Other colleagues are working on it, and so I refer to them. But what is really important for us is that one way to the meaning of rule of law for an agency is to control that agencies work under the paradigm of limited government. In short, rule of law for agencies means to control that autonomy and independence does not lead to arbitrariness. And this is precisely what has happened with the mandate of Leggeri. Therefore, it is very important that once we understand that there is a strong interplay between rule of law and accountability mechanism, we have to rethink the accountability mechanism on Frontex. I think because I have 1 minute, I can only refer to what I've been working on recently. One dimension is within the agency role and composition of the management board. I think this is something which is kind of, ignored since time as a topic, and I think it's time to rethink about it, because for several reasons. And another one is, of course, to work on external remedies. Here, there could be, it's too much to say, but the only thing we can say is that we can think at conditionality as well. What can I say about the management board is that it is the first body to exercise oversight over the agency. It is a kind of an instance of managerial accountability, but also a lower tier of political accountability. So the point is that, I'll be very brief. Which management board for Frontex? The agency has been growing tremendously in terms of organization, size, funding. The question is this management board, which is made of representatives of national administration plus the commission, still the right composition of the management board? I argue this is not the case. I think that there has to be time to rethink the functioning, the operation of the management board, and to integrate representatives of the European Parliament into the management board. Why? The discretion of the delegation of discretionary powers to Frontex, because this is what we are talking about, has also a high political salience. So it is important that the European Parliament has access to good information, has been a member of the management board means, because this is really an internal body of Frontex. So, and this is also in harmony with the principle of institutional balance. Another instrument is also, but then I close here, is conditionality. And we have seen that the discharge of the budget procedure has been showing that the Parliament is kind of expanding its role toward the stronger political accountability. And I think there should be room also for the carving out of a conditionality clause starting from Article 46 of the Frontex regulation. A conditionality starting from the role of the fundamental rights officer. This is something that Frontex, in my view, could do toward the member states, whereas previously I was referring at conditionality of the Parliament toward Frontex. I think that I closed by saying that then we have to think also to enhance ex post remedies with transparency, border monitoring mechanism, and also rethinking effective judicial review to catch all this attempt of escapes from law that we are witnessing in this domain of externalization. Thank you.
Excellent. Thank you so much, Luisa, for touching on this difficult topic, Frontex and the rule of law crisis from within, but also the external border, how it affects also tolerating the external border rule of law crisis that is very much associated with externalization initiatives. So last but not least, Professor Xanthaki, the UN Special Rapporteur in the field of cultural rights and professor in law at Brunel University London, is going to offer quite a fresh perspective regarding the effect of externalization on culture and cultural rights in Europe. So Alexandra, the floor is yours.
Thank you, and thank you very much to the previous speakers. I learned a lot, and I think that there is a debate to be had about all the aspects that they have raised, and looking forward to this debate later. I think that the issue of cultural rights continues to be gravely pushed aside in the debate in general about migration, and I just think that it is also ignored here. So my last report to the United Nations Human Rights Council about a month ago was about this issue about migration and cultural rights, and my argument in the report is that cultural rights play an important role in migration processes, and they are being violated in many situations. However, we focus a lot on the right to refoulement, the right to asylum, the living conditions, socioeconomic rights, and we have good reasons to. However, we ignore rights that relate to the identity or sometimes we don't ignore them, but we don't frame them in the context of cultural rights, which I think maybe is the case here. And just to remind you that Article 15 of the International Covenant on Economic, Social and Cultural Rights says that everyone has the right to participate in the cultural life. And by everyone, we also mean the person that applies for asylum and the undocumented or non-recognized, undocumented migrant and non-recognized refugee. And this is something that states push aside, and unfortunately we do not challenge them. So when we talk about externalizations, when these people are sent to another part, either another part of the world, but also when they are put in detention centers in the borders, the message that the state gives is that these people are going to be separate from the rest of the population, and in a way does not recognize their right to participate in what is happening around them. So their identity is pushed aside. Indirectly, the state says that their identity should not be exposed to the rest of the population. We should just keep them separately, and this dehumanizes them, and their identity is dehumanized, and they're seen as separate, different, and their rights are certainly not upheld. So this is in general this way of violating cultural rights for all. However, we have also seen that rights of artists are also violated. For example, for a long time, the US had been, although they had programs for art of prisoners in Guantanamo Bay, what they were doing is that they were not recognizing this art as owned by the artists. So the moment the prisoners would be released, they had no right to take the art with them. And my mandate managed to change that 2 months ago. But this is something that we have to keep in mind with respect to other situations. So how artists are being affected by externalization. And I think that in general, it is very interesting how states talk about integration of migrants in general, and how this is it seems to be the buzzword still everywhere. However, these externalization processes do exactly, and are set up to do exactly the opposite, to separate this category of persons, to push them aside and to exclude them and exclude their identity and their cultures from the states and the society within the states. Thank you.
Thank you, Alexandra. Thank you so much for your intervention and for this perspective on the topic that is not as much discussed, but it's necessary for us to take into account. Is your recent report on cultural migration publicly accessible at the moment?
Yeah. Yes, it is. It is. I'll send it to you.
That's great. Yeah, it would be great to have a look. Thank you, everyone, for your presentations. Now, I have opened the floor to questions and comments from the audience. I'm not sure if I have done anything, if everything is okay in terms of settings for the audience to pose questions. I think I have enabled everyone to pose questions. So until we receive questions from the audience, yes, we have a question for David. Piero, would you like to speak, or shall I read your question? So yes, Suella Braverman has said that the new migration bill will push further the borders of international law, what do you think about it? Yeah, that's. I also wanted to ask a follow-up question about this. Are we expecting to see more and more externalization, and what does the new legal migration bill, how does it play out in this respect? So we would love to have your perspective, David.
Well, thanks indeed. I mean, it's a provocative question, provocatively phrased, and it's difficult to give anything other than a very straight answer to it, I'm afraid. I mean, when somebody talks about pushing the borders of international law further, you think of the Inter-American Court, developing jurisprudence that's, extremely liberal. I don't think that's quite what Suella Braverman has in mind. I think she means breaking international law, and it's fairly clear that that's what the illegal migration bill looks to do on a number of fronts. I mean, first of all, most participants will be aware that the government wasn't able to put a statement at the front of the bill that it was necessarily compliant with the European Convention on Human Rights. In other words, under the Domesticated Human Rights Act framework there. Secondly, I think there are fairly wide questions about whether or not it's compliant with our obligations under other human rights treaties, for example, under UN human rights treaties, such as the International Covenant on Civil and Political Rights. And I've published briefings recently to the effect that it's fairly clear that the bill goes against the Refugee Convention in a number of ways by effectively declining to determine the asylum claims of people who probably, some at least, a high proportion given recent figures, are in fact refugees. States are not able to decline to determine refugee status. There are very narrow exceptions to that principle, but inverting that principle and effectively saying we're, for the vast majority of claimants, not going to do that is clearly unlawful. I wonder if the government's read the NDNT versus Spain decision from the European Court of Human Rights, and I know a lot of human rights commentators have not been particularly pleased about that, but even on the fairly narrow parameters that it sets, it's clear that if one wants to take these kinds of measures, in other words, what effectively amount to collective expulsions, then it's absolutely necessary to provide accessible and lawful routes. And the UK government's response to that has been, well, we will provide safe and legal routes at some later point when there's no more illegal migration. And frankly, that seems to imagine a world which will never exist. So I think it's fairly clear that on a number of grounds, the bill doesn't push international law, it simply breaks it. And we should be raising our voices about that, absolutely. Thank you very much for the question, Pietro.
Thank you, Piero, for the question, and David for answering. Does any of the panelists have any questions? Luisa?
Yeah. I'm thinking especially at the issues of internalization of, the shifting internally the borders of migration. So I'm thinking there which could be the solutions, because I also thought that one of the things that I fear, and I mean this question would be mainly for Vasiliki, is that there is in law we have indeed the codification of fictions like the non-entry fiction. And also then we have also a kind of a lowering down of the guarantees because the access to remedies is restrained and is limited. So I really think that, I see there a problem because, the Court of Justice has been in the past willing to, let's say, interpret the secondary law in light with the Charter of Fundamental Rights. But I think that if the secondary law is, diminishing the guarantees, I really wonder whether the Court of Justice is willing to take, a more proactive agency. In other words, I think that I see that there is a risk of the Court of Justice not putting high standards in terms of guarantees in this respect. And I think that border procedures are really problematic in this respect. I hope this question doesn't sound like how do you predict the future, but I think, it's a bit of getting, a sense of from you on this matter.
Yes, indeed. It's something interesting because also when I'm looking at the responses on externalization, at least there is something that you can think like extending the human rights framework, for example. But in the case of internalization, exactly the problem is that all these are taking place and they are presented as they are legal. They are part of the secondary legislation, and now with the regulation that will be directly implemented in the member states, it will be sure that the non-entry fiction will be applicable in border procedures. And this is what I'm also looking on my thesis. Of course, the first thing that I also thought was to believe in courts, to bring cases in the courts that concern border procedures. And when I'm looking at in the case law of the European courts, and especially the European Court of Justice, for example, I cannot see many cases that concern border procedures and Article 43, so that I believe that more cases should reach the court. There are the last cases against Hungary, for example, where at least the court confirmed that the keeping of persons close to the borders amounts to detention, even if it's not framed as such. So at least it's not contested that border procedures are taking place in detention. On the other hand, of course, we have the European Court of Human Rights, which is not so reluctant to frame area-based restrictions as detention. So there are some cases where we cannot find this standard of the court. However, I believe also that the lawyers that are working in the field, in the external borders, can help asylum seekers in border procedures to bring cases in domestic courts also. This would be also a case. And then I would like also to mention the monitoring mechanism that the Commission proposes for the screening regulation. Of course, it's really problematic that this is proposed only for the case of the screening, and it's not proposed for the case of asylum border procedure, for example, or in the case of return border procedures. So I believe also a solution could be to expand the human rights monitoring mechanism to also cover asylum border procedures, although of course this is a monitoring body, and again it's not sure that it will be independent or if there will be again some state interests. So I believe that the prospects for a magic bullet solution is slim. So we need to look also for other approaches that how can we actually try to restrict the sovereignty of the state and the possibility to shift the borders always. And because also this may has, in the end of the day, impact in other sectors if we're shifting the borders without an end. Yes, these are some thoughts, and let's see also how the negotiations will go, although I believe, and because I follow the negotiations, that there is member states insist on the wider use of border procedures. So I believe it will be finally a component of the member states. And as they are persisting, I think your question is really important, because we see that border procedures will be there and they will be extended and they will be used even more. So we as lawyers, of course, and the lawyers that are working in the field, could work on also identifying how to respond to these internalization practices and deficits in the borders.
Thank you, Vasiliki. We have a question from Mohammed Nayeri, a colleague from Brunel. What do you think is the impact of previous experiments of externalization, such as by Australia, in the more recent cases, UK and the EU, for example? I'm not sure who would like to answer this question. Perhaps David might have.
Thinking Pietro has talked a lot about practices. If you wanted to say a first thing, I'd be happy to add a couple of comments.
Well, thank you. Well, I think that the legacy of this experience is quite poor. I mean, Australia represents one of the most criticized instances. I was reading recently that there were even allegations and information sent to the International Criminal Court prosecutor, accusing, I mean, Australia of in this way to be co-responsible for crimes against humanity. The prosecutor of the ICC did not agree on the fact that the threshold of the human rights violation occurring in this context, it was the in particularly the issue was focused on the detention outside of the Australian territory in another country of migrants intercepted, I think, in the seas. And although the threshold for an international crimes for widespread violation amounting to an international crime was not there, still the prosecutor in its letter addressed to the Australian government made clear that the violations were still extremely severe and that we were talking about a human rights crisis. About, I mean, the UK and Rwanda Memorandum of Understanding, I think that a similar logic applies. We do not know, I do not know in detail how the asylum system in Rwanda works, but there are allegations of the fact that for sure it doesn't guarantee the same standard as other countries. And I think that these also could lead to the violation, to severe human rights violation, not to mention the fact that the agency of the asylum seekers is completely neglected. The case where the European Court of Human Rights intervened with provisional measures, urgent provisional measures to stop the flight to Rwanda, concerned an Iraqi person. I mean, here people are moved, I mean, wherever state wants, without taking into account their agency and their link, which is one of the key factors that encourage asylum shopping and illegal secondary movements within Europe and within the Dublin system. Until we don't take into account the needs of people who are on the move because they fear severe human rights violation, we will never approach, I think, in my opinion, a stable system. Thank you.
Another question from Gabriel Dunn. According to international law, under what circumstances would a state owe a duty of care over migrants / asylum seekers who are here to enter a state's territory? What responsibility would an EU member state have over an asylum seeker who intends to enter an EU country other than Greece, but ends up in Turkey as a result of the EU-Turkey deal? Anyone would like to answer this question or have some thoughts about this?
I mean, I'd be happy to address it and leave somebody else to address the EU angle, which is not my area of expertise. So, I mean, thinking about it from a general international law point of view, I think there's a couple of points to be made. The first of those is that clearly states which are parties to a treaty like the Refugee Convention have a duty not to undermine the application of that convention in other territories. And I think it's important, you know, to emphasize with the illegal migration bill in the UK, for example, that this idea that we can simply send asylum seekers who arrive here through unlawful routes anywhere else in the world, and that the convention allows us to do that, opens up a game in which if other states took that view, asylum seekers, the vast majority of them, who of course have to follow unlawful routes because there are no lawful routes other than to neighbouring countries, sometimes not even then, where the vast majority of asylum seekers ended up just whizzing around the world as, you know, different states tried to send them to different places. That's not the idea of the Refugee Convention. So certainly there's a duty there not to undermine the convention and its application more generally. I think there's a secondary duty, which is in relation to this idea that where actions by a state form part of a chain of conduct that directly expose an individual to breaches of fundamental human rights, then that is unlawful. So states would have that, if you like, slightly more remote form of responsibility in relation to the individuals outside their territory. I don't think that there is a direct responsibility in that sense. But thirdly, I think there is a policy or practical issue here, which other colleagues have alluded to, which is quite simply people travel by irregular routes because the regular routes have all been closed pretty much, certainly in a country like the UK. And, you know, it does seem somewhat cynical where the UK has stopped or has imposed visas on countries that are refugee producing one after another, and other states, of course, have done the same thing, and then takes a variety of measures to make any further travel by land unlawful, to then turn around and say, oh, well, you know, people should use safe and lawful routes when none exist. So I do think that there's, if you like, a sort of, perhaps not a legal responsibility, but there is some kind of policy responsibility that if you are going to take this line about safe and lawful routes, that they need to be opened up. And Pietro addressed that point very nicely, I think.
Luisa?
Yes, I take the ball that has been launched by David, because I think that, I think that if we think of the perspective of EU law, one of the issues that we have to think of and to work in the direction of overcoming is to adjudicate instruments even when they are not qualified as hard law. I think this is something that has to be worked upon, and even for Frontex, we have to work in the direction of finding ways to challenge the legality of operational activities, because this is one of the problems of the agency. And of course, then we have the problem of multi-actorness, as it has been very well explained by Melanie Fink. But I think that we have to go in that direction. And if courts still wants to keep the role of, guarantees of the legality of the system, this is also very important to do. If I can conclude with a kind of position of question mark or uncertainty, is that I'm Vasiliki indeed has also appointed to case law of the Court of Justice on Hungary, and where the Court of Justice has been proactive in finding the rights and giving primacy of European fundamental rights over domestic law. There, my question mark is, I see that the Court of Justice is wearing different hats. So when the Court of Justice is scrutinizing the legality of some member states, then it keeps a proactive attitude. In other situations, then it is less proactive. And the EU-Turkey deal is an example. The ICSIS case is also another example. So I think that there are some problematic aspects in there. But I think that, and even when scrutinizing, when adjudicating on the challenges against Frontex, also, I don't see a lot of proactivity in there. I can't go now deepen into this field, but I think that there is a lot of self-restraint when the Court of Justice is adjudicating the administration, which I don't think it is in coherence with the overall case law of the Court of Justice on agencies. So I think that the Court of Justice should be, encouraged to take a more proactive approach. And litigation is very important in this domain. Strategic litigation by scholars, by academic, by NGOs is really important in this domain, I think.
Excellent point. Golden Lang also has made this point about judicial passivism on behalf of the court. Alexandra? Is this a raised hand?
Yes, I think that in this situation, it's it's an example of how states unfortunately benefit from the fragmentation that exists between European law and European system of asylum protection, international law, and also the fragmentation between refugee law experts and international human rights law experts. And I think that, Ermioni, that in IT Flows, the Horizon 2020 project in which we participate, this is what we try to do. We try to put all together. So if a state has control under international law, and the European Court of Human Rights has said that if a state has control over a territory, then, and control, we can discuss how it is going to be defined, then the state has the responsibility to ensure that human rights are respected. So if we're talking about a specific, hotspot in Rwanda or a specific area, somewhere else, it is still the state that has responsibility, first of all. Secondly, again, my argument of before, we tend to focus on the specific rights in international law, and we don't focus on the overall violations. So a lot of these violations are customary international law, even peremptory norms of international law, which means that they don't just apply vertically, but also horizontally. So everyone, irrespective of which territory they're in and, who they are, have to respect them. So I think that we need to put pressure on states in a more, we all people who deal with this issue, I think that we need to put pressure on states with arguments coming from constitutional law, from European law, from international law, from refugee law, but also from general international human rights law. And I think that only then are we going to be more successful.
Excellent, thank you very much. Yeah, there is definitely a lot of work to be done on many fronts, and I hope that this panel discussion has somehow contributed towards this direction. Thank you everyone for your time, for being here and offering your amazing insight, and thank you everyone in the audience for joining us and participating. We will be back with more discussions hopefully next year. Until then, see you everyone, and I wish you all a nice Friday and a nice good weekend. Bye.
Thank you. Bye-bye.
Bye. Thank you very much.